Welcome to the Business Seller Center Expert Interview Series. Today we're talking with Attorney Joe Fournier about legal agreements that can make or break your business sale. This is interview number 3 in our series. Joe Fournier is an attorney who has more than 20 years of experience advising and leading companies and individuals in many different capacities. Joe has significant experience in a variety of business legal matters, including startups, company formations, as well as mergers and acquisitions. He also handles estate planning matters such as business succession planning, wills, trusts, and probate. Joe received his law degree from University of North Carolina, Chapel Hill School of Law, and his accounting degree from University of Rhode Island. He is admitted to practice law in Connecticut, Mass, and Rhode Island, and he's a CPA. He has periodically been an adjunct professor and a lecturer at the university level and has been a frequent speaker on business planning and legal matters. So this is another episode of the Expert Interview Series, and today we're talking with Joe Fournier. And Joe, thanks for being available for this.
Sure, Kevin, thanks.
So the overarching thing we're trying to do with this series is educate sellers and have them think how buyers are going to think when they're looking at selling their business. And we want to simplify the process. We want to help our sellers get the maximum value that they can. And as advisors to the process, we also want to learn from the mistakes and the problems in past deals so we can make our new deals and our future deals be more seamless, happen quicker and easier on behalf of sellers and buyers. So does that sound like a good premise?
Love it. One of my favorite topics.
All right, great. Yeah, and I know you've been involved in lots of commercial business transactions. Do you want to just say something about that in terms of kind of your experience and just, big picture of what you've seen and what you like to bring, as an advisor?
Sure. Yeah, that's great. I actually really do enjoy working on deals like this. We do a wide range of services here, and not all of them end up with people happy on both sides. And one of the things that we really enjoy about the transactions is that at least there's that opportunity for both sides to be satisfied at the end and happy with their deal. Usually the seller, for obvious reasons, is happy if they're getting paid and kind of moving forward and closing that chapter.
Sure.
And the buyers are super excited and energized by the opportunity to run the business.
Great. Yeah, so it's not necessarily like like a divorce or somebody's getting sued. There's an opportunity for both parties to be satisfied. Of course, they got to meet in the middle. There's negotiation involved. But it's like they're both moving towards a future that they're excited about, hopefully. So yeah.
And they're there because they want to be there, not because someone dragged them to the table.
Not because they got served.
Right. Exactly.
Yeah. No, again, I love working with sellers, but for every seller that I represent, I might have to talk to 50 buyers. So that's a huge part of my practice is helping them, and creating with them and on behalf of the seller a process, a sequence, steps, things that we know as advisors, like we know you're going to have to do these things, whether it's, a tax clearance, or it's, due diligence items. So again, one of my big premises when talking with people is that an educated seller and educated buyers are better, and it makes the deal flow better when people have the more they know about what they're going to be in for. So that's part of the purpose of this series, is to invite experts like you who've seen more deals. Like most sellers are just going to do this once in their life, maybe, right? It's really helpful to have somebody like you that's done it like a whole ton of times. So great.
That makes sense.
So, again, big picture kind of question. There's some legal documents that are really critical to this process. And there's 2 that I'm thinking about. And if there's other components and other things that you've seen again and again, please bring those into the conversation. But I'm thinking primarily of, kind of the offer letter, we'll call it the letter of intent, that's early on in the process. So again, sellers might have a lot of interest. I had one recently where I had about 20 different buyers looking to make offers. And so there's this letter of intent that a good one will explain a lot of things about what their offer is. And then that'll lead to the purchase and sale agreement or the asset sale agreement, or whatever form and document we're working on. But I've had a lot of buyers just like, they'll text me an offer. Oh, I'll give you 800,000, give you 4 million for the business. It's like, that's not an offer. I appreciate you're busy and you're driving, but that's not an offer.
I mean, they only texted it because there wasn't a napkin there.
Yeah, exactly. Yeah, I wasn't across the table from here.
We couldn't do the handshake through the car.
You slide over here. Here's my offer.
Right.
Like, so I think of that scene in that movie, Moneyball, where the guy hands the offer over on a napkin.
Right.
So what can you share about the importance of a good intro, like a letter of intent at the beginning of the process? Because one of the things that happens almost all the time is we take the deal off the table. It's like, now we're not fielding offers from anybody else. We're not negotiating.
Right.
The business is kind of off the market. So it's like, you're getting into bed kind of with this buyer. We want a really good letter of intent. Hopefully that'll lead, flow into a purchase and sale agreement. So
sure. And I think you just hit the nail on the head with probably the most important part of the letter of intent is sometimes is not highest on the radar screen, but that is the exclusivity provision that should be in there, right? So
yeah.
The seller, if the seller is giving exclusivity,
right,
then the seller certainly deserves to know a lot about the deal terms, right? So the better the LOI is, the more clarity there is to it. Mm-hmm. Usually, in my experience, spending time on the letter of intent up front, mm-hmm. while it may frustrate the parties who may be uneducated at first, certainly leads to a smoother process towards the close and, frankly, less overall cost because it makes that latter process less of a headache for everyone.
Right.
Obviously on the buyer side, the buyer wants exclusivity.
Right.
So it's in the buyer's interest to give the seller what he or she needs to give up that right to talk to other parties.
All right, great. So, do you recall times or were there deals that you bumped into over the years where there wasn't a really good offer or early, like a letter of intent, which in most cases is a non-binding offer? So that's the challenge for the seller, mm-hmm. is that they're taking the business off the market. They're giving this exclusivity and time for the buyer to do their due diligence, but they're not talking to somebody else. So there's a bit of risk, for the seller there. Do you recall times where they're like, maybe you got involved in a deal after the previous attorney didn't do a good job on a letter of intent, or where things blow up kind of at the time for the purchase and sale agreement because they weren't brought up?
Absolutely. Or similarly, not necessarily when a prior attorney was involved, but someone who tried to make a run at it without an attorney.
Oh, great point. Yeah.
And then called me at the last minute.
Yeah.
Like, I can do this. Here we're at.
I can do this on my own.
Documents. Like, how am I supposed to properly advise you if I don't have some idea of what the structure of the deal is supposed to look like, right? Yeah. So the LOI is kind of the beginning of that journey. And yes, I have stories on both sides. I have stories where we did not have a letter of intent or any kind of structure really upfront.
Okay. Yep.
And it does create more legal work, and it does create some confusion at times, not always, but sometimes. On the other hand, I've been in situations where we spent what appears to the parties, it appears to be an inordinate amount of time on the letter of intent, but that pays off for sure a couple months later when we're finalizing the deal docs, and when there's some confusion, the letter of intent is kind of our roadmap. We can look back to that and clarify things for both parties.
All right, great. Yeah, because I've seen that happen where if the quality of the letter of intent isn't there, it's not as comprehensive, they try to just get it done quickly. We know the issues that are going to come up when it's time to execute a purchase and sale agreement. Like, so why not move those forward? And if, again, it's not good if a deal blows up or doesn't move forward with a particular buyer. But if we can identify things early on by being a little more rigorous with the letter of intent process, well, maybe we find out that this isn't going to work. The sooner we find out it isn't going to work, the better. Because then we
Right.
can go back to market. We don't have to waste a lot of
Right.
time in due diligence.
Right.
Yeah.
Right. That's a great point.
So, so I might be paraphrasing what you said, Joe, but you would recommend that a seller have an advisor versus using like Rocket Lawyer?
Yes. Yes. There's just too many important provisions in these agreements.
Yeah.
Maybe they don't appear important initially.
Yeah.
Maybe there's a lack of understanding by one of the parties or one of the attorneys even as to the importance of a certain provision with regard to a deal type, deal size, industry type, seller stage of life matters, right?
Yeah.
Some sellers want to hold paper, some don't, some long term, some short terms. And, you know, I think that while there's a generally the buyer and seller are going to be on the same page with regard to getting a deal done.
Right. Right.
Buyers and sellers have different interests throughout that process.
Sure.
Right. The seller wants to close the deal and minimize the risk that they can get closed and paid and not have to worry about a tail of liability or, you know,
performance of the buyer in the future.
Right. They're moving on with their life. That's and they deserve it, right? They built it. They deserve to capitalize on it and to move on. Whereas a buyer, certainly it's exciting for the buyer, but the buyer is entering into some unknown territory.
Yeah. With
regard to customers, employees, could be potential liabilities. And so there are a little bit slightly different interests there when you're negotiating the legal documents. So it's impossible for me to believe that a template would be able to cover both sides' interests. It's not possible.
Yeah. And in all circumstances, in all industries, in all markets. Yeah. Especially with, you know, pandemic issues have really changed the nature of things in terms of due diligence, financing, the way SBA lenders look at deals. I'm sure there's, you know, from a buyer is going to want to have some different level of assurances and maybe some kind of carve out or retention, you know, carve out because of COVID. So I don't know if you've been bumping into that as an issue in deals or.
It's such a great point, Kevin. It really is an evolution, right? It's amazing that 2 years ago, that simply was not an issue in any of our deals.
Yeah.
Now it's an issue pretty much
all the time,
every deal, because pretty much everyone received either some kind of SBA money, right? It may have just been an EIDL, the Economic Injury Disaster Loan. And it's interesting how the SBA has been handling that and during the transfer process. And of course, they've been better, I think, than we anticipated. They want deals to happen too. They understand that commerce needs to move forward. But that's a great point that you brought up. That's something that was not even on the radar screen a couple of years ago.
Oh yeah, and it's you know it's absolutely impacted valuations and the approach, the methodology of looking at a company. I mean, I got to go back 5-6 years. I want to see a baseline of like their revenue and earnings pre-pandemic, and then how did they respond and where are they at? You know, almost 3 years later. So yeah, I'm sure there's a lot of legal aspects that are related to, you know, the financial aspects, disclosure aspects, you know. Most of the businesses that are sold debt free, so the seller's got to clean up any kind of obligations.
Right.
So what are the kind of letter of intent categories? So and like you said, it's not just about price. It's not I'll just give you $5 million for your business. What are the things that you think are maybe the most critical components of a good letter of intent that most sellers and buyers aren't just already thinking about because they just haven't done it?
I certainly purchase price, like you mentioned, is always important, but the devil is in the details when it comes to the purchase price. How is it getting paid? What are the expectations with regard to timing of that? If there's debt, what does that debt look like? Does the buyer have to come in with cash and get his or her own financing? Or is that something the seller? So that is certainly, obviously, a major component of any letter of intent. But some of the other things that pop up would be, and this is a big one that pops up in almost every deal, would be the post-closing involvement
All
of
right,
a
great,
seller.
great.
So, is the seller going to stick around, not stick around, help with the transition or not? Is the seller going to have an employment agreement, or is the seller going to be required to sign a non-compete,
Mhm.
which may be totally acceptable.
Yeah,
But
if
each
they're
deal
retiring.
has nuances. Right.
Yeah, yeah. No, and actually it's one of the things I try to kind of take a temperature of the sellers early on, because the best sellers are a little bit flexible. Like if you think you're going to show up at closing and it's going to be all cash and then you go sail into the Bahamas, well,
Right.
yeah, you can ask for that, but you might take a haircut. But if a seller is willing to stick around, they appreciate the need to be available in the transition period, whether it's 3 months or 9 months or a year. Again, every industry, every business is going to be different. Whether it's compensated, whether there's a tail and some retention of earnings or a payout in a year or two. So yeah, these things. Again, if I'm helping to bring these into the conversation early on, then it helps me be seen as an expert, as you are, and it helps elevate and accelerate the conversation. Because, like you said, the devil's in the details, but time is also the deal killer. If we can get the deal done in 3 months, that's better than 6 months. 5 months is better than 12 months because people lose enthusiasm over time, right?
And I think too, in having clarity, it's not. I think having the clarity up front, and you've brought this up a couple of times with the benefit of the LOI in the process, having that clarity up front is very rarely a negative thing, right? The more we know up front, the more the parties come to the table understanding what they want post-close is very helpful as part of that process. So let's address it up front when we can. Not under the pressure of a closing deadline. The other thing too, not to harp on this too much, but we did mention it earlier, so I want to mention again. The exclusivity is something that's super important in the LOI. Whether there is exclusivity and then the length of time of that exclusivity with regard to the closing date. Because if at some point the seller may have to have a fish or cut bait conversation with that buyer.
No, I've got a closing coming up in about 10 days, and that was a big issue. It's like we created actually a timeline of kind of expectations in the LOI that talked about the due diligence cycle and what we would do and how the seller would be available for the buyer. So I think we did a good job of that. But the calendar kept, the attorney's away, the CPA's away, I'm going on vacation. And it's like, managing to those expectations is critical. And we were almost getting to that point where it's like, are we doing this or are we not doing this? It's like one of the other things that I've been putting in or requesting in the LOIs is what's the expectation for the buyer to generate the purchase and sale agreement? Because we want, in most of my deals, I'm asking them to bring that. They bring the first draft of that, and we try to give them a little bit of guidance for that. But it's like, we got to get that done now, not when we're done with due diligence, because then now the calendar is way out there. Like, let's get the purchase and sale agreement done. 2 weeks is better than 4 weeks while you're doing due diligence. So we do these things in parallel. We're stacking them up instead of them being serial, which just takes forever. So yeah, that's something that I've been trying to pay attention to with buyers and sellers is let's put something in here about timing, expectation to close, the timing and the expectations for due diligence, the requests that they might have for due diligence. I want to come in and interview employees. It's like, maybe that happens after we sign the purchase and sale agreement. Maybe that doesn't happen with the LOI and the due diligence period. So a lot of flexibility and a lot of nuance in there. Great. Yeah. Any other kind of critical things or things that you've seen recently that maybe are a little different, whether it's because of the pandemic or supply chain issues, or it's like people are having trouble. We got inflation, supply chain, pandemic, trying to find good people. Like that's a quadruple whammy of for business owners. Are you seeing any of those more current issues showing up in agreements in any way?
I would say for sure in the agreements and sometimes in the letter of intent also, that can be an opportunity to address certain things like potential employee retention or not.
Okay.
And then also things such, more legal terms such as indemnification
Right.
terms and what those dollar amounts might be. I think there have been times over the last 2.5 years where there is just a general uncertainty,
Mhm.
and because of the things you just mentioned.
Yeah.
And maybe there is the SBA loan issue
Mhm.
that's hanging over their head that wasn't there before, or
Yeah.
maybe there are employees who maybe don't want to stick around under a new regime because they've been through a lot over the last couple
Yeah.
of years, and they just have a different perspective now.
Yeah. Great, great. Yeah, that was one thing a buyer just wanted to put into a recent purchase and sale agreement. It was like, if you lose a key person, I want your assurance that you'll be around to help me hire and train the next person, because the seller didn't want the buyer to be interviewing the employees and talking with them about their plans
Right.
post sale because they didn't know about the sale. So
Right.
I only have one deal where the whole team is on board. The gal that's selling, everybody knows, and that's just a choice that she made. Most people don't want their people to know.
Right. Right. That's
So,
rare. Right.
yeah, and that can be an important point in the LOI and in the purchase and sale agreement, like access to premises, to team, documentation and reporting. But it's like, yeah, this is understood that this isn't public information.
Confidentiality. Correct.
Yeah, yeah, yeah. So any kind of thoughts about the purchase and sale agreement compared to the LOI, like in terms of just your thoughts about the timing of it, the negotiation of it. Again, we kind of hit this earlier, about a good LOI kind of presupposes a lot of the things that should be in a good purchase and sale agreement. So there should be a substantial amount of overlap. There shouldn't be like new things in the purchase and sale agreement. Like, we never talked about this.
Right.
What's this?
Right. That's a good point. It's going to give you the roadmap, but what you won't do in the LOI is get into all the details of some of the legal nuances, right? So
Yeah.
in the purchase and sale agreement, one of the sections that we negotiate heavily would be the indemnification provisions.
Okay.
So, for example, if the buyer buys a liability that he or she didn't know existed, is the seller on the hook for that, and to what extent?
Okay.
Right. And then often we'll negotiate, and I'm sure you're familiar with the term of a basket in the indemnification. So the seller, we talked earlier about the seller kind of moving on with her life or his life. They don't want to be nickel and dimed over the next 18 months for small stuff.
Right.
So unless the buyer reaches the basket, let's say it's 5,000, 10,000, whatever it is, could be more.
Right.
Then there's no indemnification that kicks in. So that's just an example of a legal, you're not going to get that in a boilerplate, obviously. You're not, and that's something that's negotiated. And there's so many factors that come into play there. It could be deal size, deal price, industry, risk profile, buyer, seller, market. All of that affects something like an indemnification provision.
Oh yeah, and if it's a property that's also going along, if there's real estate and we need to do an environmental analysis, or it's interesting what you were just saying, because the seller may not knowingly be trying to hide something from the buyer, and it may just be, oh, this didn't come up. Doesn't mean the liability went away because they didn't bring it up. So it may not be purposeful that they were hiding something. That's a whole nother level.
Right.
Like, oh, you didn't ask and I didn't say, and it's like, oh yeah, I forgot we have this oil tank out in the backyard or something,
that brings up a good point too. Earlier we talked about the letter of intent. We talked about the purchase price, and I said the purchase price is one thing, but there are a lot of details in that purchase price that need to be worked through. And one of the big ones, and this comes up a lot, is whether money will be held back in escrow.
Okay.
And whether it be for something you mentioned earlier, which is the tax clearance.
Yeah.
Or whether it be for indemnification obligations, or whether it be for some kind of a performance measurement going forward. Right. It's important that the parties are on the same page with regard to how much may be held back in escrow.
And under what terms
for that release. Right.
Yeah. So it's interesting when you're talking about that specifically, Joe, like there's some of that, it may be hard for the buyer to know to put that into a letter of intent because they just haven't seen enough about the business. But it's like, oh, there's a risk item. I'm going to want a little coverage and protection on the backside. So then there would be a conversation. Hopefully it wouldn't, like I had a deal where people just injected stuff in a revised agreement that we hadn't talked about.
Sure.
Come on. It's like, yeah, I know it's like buyer beware, seller beware, but it's like you can't just add stuff in unless we've kind of had a conversation about it first, don't you think? So,
well, and I don't know, with regard to your work, I'd like to hear if your experience is different. My experience generally has been sellers are generally okay with money being held in escrow. Usually we'll hold it, or the buyer's attorney, but usually we'll hold it. And actually, usually the buyer's attorney will hold it.
Right.
Release it upon certain terms. The sellers, in my experience, have been pleasantly, by the way, they're fine with that as long as they understand the details regarding how it gets released, because the seller has confidence in their company.
Yeah, they know the operation, they know the risks. It's like, well, I got a problem with your HVAC unit up on the rooftop, and if that can get us through the winter, you're saying it's been maintained forever, but if it fails this winter, that's maybe a picky unit example, but it's like,
well, that one comes up though. That one comes up.
Yeah, it's like it's like, representations and warranties. It's like you're telling me that this stuff is all good. Well, what if it isn't? I'd like to just put this aside. If we make it through the winter without spending more than the regular amount of maintenance, I don't have to replace a whole rooftop unit, then we'll release that, April 1st,
Right.
But yeah. So have you seen any challenges, or I'm just curious also your kind of view, Joe, of the pace of things? Do you feel this is with inflation and with markets and uncertainties, do you think that's having buyers be more or less interested in doing deals, or do you have any kind of sense of what's going on in the industry from your perspective?
Yeah, I mean, Kevin, I think obviously when the buyer has to get their own financing, that can slow the process down a bit.
Right.
Whether it be a bank or a family or friends fundraise or whatever.
Right.
They also tend to need more information up front in that environment.
Okay.
Which can certainly cause some lags in the process. And that really doesn't go to the seriousness of the buyer. It just goes to the logistics of how to get the money.
Yeah.
And sellers that are willing to self-finance, I mean, obviously you don't come out of the gate recommending that, I'm sure, to most of your clients.
Yeah.
But there are times where it's an acceptable compromise for the seller, especially if they get cash up front and they, to your point earlier, they really know their business. That can be very acceptable because it helps get the deal done.
Oh yeah. No, again, the more flexible the seller is, the more likely we'll get a deal done. But I've counseled a lot of sellers. It's like, let the bank be the bank. You've had your blood, sweat, and tears and risk in this business.
Of course. Right.
You don't have to hold the note. So in all my deals, like a couple of the things I do before we bring a company to market is I start setting up SBA lending facilities. So I'll reach out to 2 or 3 or more SBA lenders that maybe have experience in that industry or that deal size. They're not all SBA lenders are created equal. And the other thing is to build a really good data room that's got 5 years of financials, 5 years of tax returns. It's got other operational information. So of course, buyers don't get access to the data room until they've signed a non-disclosure agreement. But if I can go to market and let the buyers know, hey, here's a deal, we've got 10% down SBA approved financing, that is kind of a game changer. Yeah, I don't like, again, when you get to the end of due diligence and the buyer's like, okay, this is great, let me just now arrange my financing. No.
It doesn't work that way.
Let's start doing that now. So when it's time to do the purchase and sale agreement, we can close in a couple of weeks because we already have a commitment letter from the lender,
Absolutely.
Yeah. So, so any other thoughts? I think we can, we're kind of moving towards wrapping this topic, and we might have some other topics for another interview, but, if the nominal theme is that a good, well thought out, well prepared letter of intent, although the pain for the seller and the buyers, it might take a little bit of legal counsel earlier on, but if that's done well and thoughtfully, that's going to flow through to a well crafted, and likely mutually agreed upon purchase and sale agreement, right?
Right.
Yeah.
I would agree. And I also think, one of the key, we just didn't mention it, but one of the key documents throughout that process is that LOI can lead to what we refer to as a closing checklist.
Mm-hmm.
And I think having a closing checklist early on in the process, after the LOI, obviously,
Right.
but before the deal docs are done, it's the, what needs to get done,
Mm-hmm.
when is it getting done,
Yeah.
and who is doing it. And
Yeah.
when you have that, and both parties now are driving towards the same
Yeah.
end goal at the same pace with no surprises when you do that. So
Right.
we often will take the LOI, take some of the key terms, put that into a closing checklist, and then use
Right.
that as our guidebook towards the
Right.
close.
Yeah, it's again, it's the things that are upsetting and frustrating for people are the things that, oh, I didn't know I had to do that, or that's
Mhm.
going to take more time. So it's again, it's I think contingent on us to bring the clarity, because we're the ones doing, like, leading them through the process that they may not be familiar with. Some buyers have bought companies before. There's some professional buyers, the
Sure.
hedge funds, private equity groups, family offices. But a lot of times it's like, husband and wife, they're buying a business because they want to be done with the corporate world and they've never done this before. So,
Right.
all
Right.
right, great, great,
Yeah,
great.
I think, yeah, that's a great point. That's a great point.
Yeah. So, yeah, so hire counsel early on. If you don't have somebody, I'll often ask my clients, like, do you have a commercial attorney that you've been working with? Do they have any experience with this? Because a lot of times the answer is, oh yeah, my attorney said he could do this. It's like, yeah, but is he going to be cracking his law school books or finding templates, or how many of these deals did they do last year or in the last 3 to 5 years? Because I don't
Right.
want my guy learning on my dime. I'd like them
Right.
executing and advising me and putting this together. So yeah, I think it's probably helpful when you've done this a few times.
It is. No, it is. It definitely takes away the traps and the tricks towards
Mhm.
the end of the process. Like you were mentioning earlier, someone who hasn't done it before, and all of a sudden, for example, when this came up in a deal recently, we're selling, as part of the deal, we're selling vehicles,
Okay.
trucks,
Yep.
equipment, and our guy didn't have, he had debt on those
Mhm.
vehicles, and there was this whole confusion near the end because the buyer didn't really understand the UCC lien process and how to do the
Okay.
payoff letters, and not a big deal. I mean, certainly something that we were able to overcome.
Yeah. And it
Um,
happens all the time.
correct, correct. And when there's the intent to get the deal done, it gets done.
Yeah.
Right? Those are just speed bumps along the way,
Yeah.
but it probably costs both parties a little extra money and time
Yeah.
because everyone's scrambling at the end to
Right.
get documents that had the buyer's party understood the process early on.
Yeah.
We probably could have gotten there a lot smoother.
Yeah. And that's a great point. Again, that, if you've been around these kind of deals for a long time and you've done a lot of them, there's things that as an advisor you can anticipate on behalf of your client, whether it's the buyer or the seller, to smooth out the process. It's like, I know these are going to be issues. Listen to me. I'm going to
Right.
help you with this. We don't want to wait and do this some other day, because if we have a timing for closure or we got a timing for due diligence, these things need some time and attention. So yeah, being
Right.
prepared and having some experience in this is so valuable for the seller or the buyer to have somebody on their team, in the CPA seat, as well as in the intermediary seat that I take, as well as
Right.
the legal seat that you take. People need a team around them, and I say let's get your team on board, very early on. So,
Right. Right.
great, great, great.
Absolutely. We
Yeah,
usually, we actually have a little process that we share with our clients up front,
yeah.
just to kind of give them a snapshot. It's not the gospel, but
Okay.
it's something that, gives them an overview. Okay, this is a process.
Okay,
There are steps. It's
great.
not like, you make a phone call and then you get a check, right?
Yeah,
There's some stuff that goes on in the middle.
sure.
I can't share my screen right now, but if I have a copy that I can send it to you after you probably have your own too.
That's
So,
actually, I was just thinking that maybe we can share that as a download for the viewers,
yeah,
and they can see, oh, here's some, work product from your firm, but also educational piece. Like, these are the things. Oh, wow, I never thought about these things. I
right.
can see why they're important. Um, I'd love to do that. So if we can plan on doing
Okay,
that,
we'll do that.
we'll
It
create
helps with managing the expectations on the timing too, which you've brought
Great.
that timing issue up a few times. So,
Oh yeah, yeah. These deals can take some time.
yeah.
And I have, I'll often have people say, "Oh, we'll get the due diligence done in 3 weeks, and we'll have a purchase." And say, "Okay, well, let's see, let's
Right.
see how that goes." So, well, I really appreciate your time and your thoughts, and again, primarily your expertise that you bring to this conversation. And I think we might have some other topics and nuanced things that we can do in another interview.
Yeah, I love it. Thanks, Kevin. It's
But
great.
yeah, thank you so much. Have a good rest of your day, and
You
we'll see you
too.
soon.
All right, take care. Bye.